Hi, I am Alejandro Herrera. This is my topic, judicial process in times of pandemic. At present, speaking of access to justice as a fundamental right would imply the judicial administration incurring excessive expenses that allow each Colombian citizen to enter the judicial apparatus in an equitable, timely, and effective manner in order to be able to settle their particular controversies and search through the system the conflict resolution mechanisms establishing in the national law. From this perspective, not only must technology to be implemented, but in turn, citizens must be helped to know them and have scope for them, in the same way that they have the ability to promote incomprehensive solution without having to use face-to-face justice, and incidentally they can progress towards total virtuality. The COVID-19 pandemic has forced all societies in the world to modify their realities that were already established for decades, and it has been necessary to try to adapt the population to what would be the new era of total virtuality. However, in the field of justice, seeking a restructuring is a very abrupt chance for her, since from its very foundation it has been understood that justice is a way of expressing the rights and duties of each citizen in order to seek a proportional equality. On the other hand, within the framework of user expectation, the confinement situation should not have become an obstacle to the effective execution of fundamental rights of the social rule of law that allows effective access to the administration of justice, especially when the citizen confidence indicators in normal times reflected a clear dissatisfaction with the lack of practice and agility in the provision of the essential service. Both Colombian and the other countries of Latin America and the world found it necessary to create the series of strategies that privilege the use of digital tools for the normal provision of the justice service, using work at home through the use of technologies of information. Except exceptionality in urgent case, the judge used all these tools to fully comply with their action, notification, proceeding, and the hearing, as well as the lawyers, plaintiff and defendants, and other intervening parties were part of said process, avoiding endless formalities. In conclusion, virtual justice has had good things and bad things, since the different platforms for the presentation is lawsuits have been collapsed, and there is also a lack of knowledge on the part of the citizen of the different platforms created for exercise their right of access to administration of justice. Likewise, for others, the presentation of lawsuits through the different virtual mechanisms has been very useful, since there avoid the displacement of people and the performance of face-to-face procedures, and significant time saving were also seen.